The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court, now sitting.
Please be seated. Good morning. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the morning docket.
Thank you, Your Honor. The first case on the 9 a.m. docket for Wednesday, December 11th, 2024 is appeal number 128062 in the matter of Alejandro J. Solorio, original action and attorney discipline, no briefs filed.
Good morning, and may it please the court. Kate Duncan Butler appears on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
Madam Justice, may it please the court, Mr. Alejandro Solorio appears in person and with counsel Rick Gwynn, and we are ready to proceed.
The second case is appeal number 128210 in the matter of Lane Charles Rundus, original action and attorney discipline, no briefs filed.
Good morning, Gail Larkin, Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator. I'm present and ready for argument.
Lane Charles Rundus, pro se. I am ready to proceed with argument. Thank you.
Your Honor, that concludes the docket for the week of December 10th through 11th.
All right, thank you. I would ask counsel in 128062 to please come forward. And take your time getting settled, but Ms. Butler, when you're ready, you may the lectern.
Madam Chief Justice, and may it please the court, my name is Kate Duncan Butler, and I'm appearing this morning on behalf of the Office of the Disciplinary Administrator. I would like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving the respondent, Alejandro Solorio, who has been licensed to practice law in the state of Kansas since 2000. This matter comes before the court after an evidentiary hearing held on June 25th, 2024 that included a joint stipulation by the parties. In that stipulation, the parties agreed to the facts underlying the case, as well as violations of KRPC 1.1, competence, 1.3, diligence, 1.14, communication, and 8.4 subsection C, misconduct involving fraud, dishonesty, deceit, or misrepresentation. In the final hearing report, the amended version of which was filed on August 13th, 2024, the hearing panel found that Mr. Solorio violated these rules. They recommended that the discipline be a published censure. No exceptions were filed by the parties, meaning that the only issue before the court this morning is the appropriate discipline. Today, as at the hearing, the disciplinary administrator is requesting that Mr. Solorio's law license be suspended for a period of 1 year. However, it is our request that after 90 days of suspension, Mr. Solorio be placed immediately on probation for a period of 18 months with the probation plan and the practice supervisor that was outlined at the hearing. This case is somewhat technical because it involves immigration law. So I will do my best to succinctly summarize the facts, knowing that there is some background into the immigration process that is necessary. A husband and wife, who I will call the clients, came to Mr. Solorio first in 2009 for assistance in seeking U non-immigrant status, or what is called a U visa. This is a special legal status in the United States. If granted, it lasts for a period of 4 years. An important aspect for this case about U non-immigrant status is after 3 years on that status, individuals on that status may apply to become lawful permanent residents or obtain a green card, as it's sometimes called. The clients received their U non-immigrant status in 2010 with an expiration date of July 13th, 2014. In March 2014, in anticipation of that deadline, the clients returned to Mr. Solorio for assistance in seeking adjustment to lawful permanent resident. Mr. Solorio met with the clients. He got the information that he needed to do those requests. Importantly, a request for adjustment must be filed while the individual is still on U non-immigrant status. Mr. Solorio has stipulated that he put the file aside. He did not timely file that request. It was filed on August 1st, 2014, so about 2 weeks after the U non-immigrant status expired. Because the status had expired at the time the requests were filed, USCIS denied the requests in February 2015. The clients therefore lost their legal status in the United States. Their work authorization had been extended while the requests were pending. They also expired, meaning they lost the ability to work legally in the United States. Mr. Solorio met with the clients and told them about the denials, but did not explain why they were denied, AKA he did not tell them that he had filed them late. From that point until the clients hired new counsel in 2022, Mr. Solorio, when he spoke to the clients, told them he was working on the case, things were happening, the case was moving along. That he was not taking affirmative steps in the case when he was making these representations. He anticipated sort of the ordinary course of action would be that his clients would receive a notice to appear before an immigration court, and at that time, he would be able to accomplish the adjustments through a process called cancellation of removal. There is testimony at the hearing that his clients would have fit the criteria and he would have been able to use that procedure. At that time, it could take about 2 years for a client to get a notice to appear. These clients never got such a notice, but that was Mr. Solorio's plan. However, his clients didn't know that was the plan. They just were told something is happening, your case is moving along. At different times, as time proceeded and they weren't noticed to appear. For instance, at one point, Mr. Solorio had them fill out new paperwork to again request adjustment. He ultimately determined that wasn't a solution, but in a voicemail, which is part of the record, the voicemail itself is Exhibit 5. It was translated into English and that's Exhibit 6. He said he was waiting to find out if the paperwork had been received and they would get a case number. He had not actually sent the paperwork anywhere. Compounding all of this was the fact that there was a presidential election in 2016 and the new administration that took office in 2017 had a different view of immigration as previously. And so to bring his clients before immigration authorities after that change in administration carried new and more complicated risks due to the new way immigration was being treated, for lack of a better description. And so Mr. Solorio continued to, when he would talk to the clients, say things are happening because he wanted to assuage the fear and anxiety that they were experiencing at that time. He has stipulated that the things he was telling his clients were not true and that he should not have been doing that. Eventually, the clients retained new counsel, learned the true reason for the denial, namely the untimely filing, and learned that Mr. Solorio had not done anything additional in the case as they thought he had. With the assistance of new counsel, they subsequently did regain temporary lawful status and have filed requests for adjustments. The stipulation provides that they expect to learn the decision on that request in 2025. So as I stated before, this case proceeded to hearing. The formal complaint was filed in October 2023. The answer in November 2023. There was an attempt to enter a summary submission agreement, but it was rejected by the chair for the Board of Discipline, which led us to a hearing in which
the reason why that was rejected?
I'm sorry?
Was it specified why that was rejected?
My recollection of the order is that it states it was not appropriate in this case, but that is all that it said.
Okay, I was curious about that because we have the copy of that report, but.
Yes, I believe the order does not go any further than that.
Okay, thank you.
You're welcome. As I said at the hearing, our office had recommended that Mr. Solorio's law license be suspended for a period of 1 year. but after 90 days and being placed directly on probation, the rest of the suspension to be stayed for the 18-month period of probation. Mr. Solorio had requested a 6-month suspension, but with immediate stay and placement on probation, again for the 18 months. The hearing panel recommended a published censure. Our recommendation remains the same for 2 reasons. First, Mr. Solario's initial negligence in not timely filing the request compounded the harm through his repeated dishonesty for a period of years toward his clients, a very long duration of dishonesty. It caused his clients to not truly know what was happening with their case and to lose decision-making power in their case during that time. Additionally, the standards support suspension. Many of the ABA standards for imposing attorney discipline, when it is knowing conduct, the appropriate discipline is suspension. In fact, the standard 4.6, which is the standard for a lack of candor toward clients, states that suspension is appropriate when a lawyer knowingly deceives the client and that deceit causes injury or potential injury.
Well, that was the panel's whole position though, right? That from their perspective, that did not cause the injury in question. So I'm interested in your response to sort of the panel's analysis on causation.
Yes, so the panel, we did not take exceptions to the panel report because in the sense that the initial harm of losing legal status was caused by the negligence and not the dishonesty, that is accurate. However, it is our position that the harm was compounded by the dishonesty because had the clients understood and known at the time, here is the reason for the denial. Here is what a strategic path that I see going forward, waiting for immigration court, is here are your options. The clients may have made different choices. When the clients did obtain new counsel in 2022, they were able to regain temporary legal status. The record is not clear on exactly what that mechanism was, but the fact remains that there may have been other paths forward that the clients, whether they sought a second opinion, whether they spoke more with Mr. Solorio about what those options are, could have undertaken. And instead, the period in which they were without legal status was longer than it may have otherwise been because they did not fully know their options or understand what they could do going forward. And so while it may not have been the precise trigger of the harm, it is certainly a compounding harm, and it put them way further down the road to having the legal status that they sought in 2014.
Yeah, and essentially depriving them of the ability to control their own decision making.
Yes, I would agree that as well. And they lost the autonomy, and as the client, they are the decision makers in their case. Although the attorney, certainly selects the means and assists in sort of what the goals are, they should have been able to make those decisions, and they were not able to. Justice Sandra, did you have a question or?
Well, I did have a question. I didn't really understand that causation was the issue, but in the findings of fact, and I know that this is, your position is different than, so maybe you could help me understand. He, in number 32, the respondent had the clients complete a second set of requests and telling them in the voicemail that he had submitted them and needed to find out the case number. The respondent did not file these requests, but he did not tell. And then number 33, he informed that he had spoken to USCIS, but he had not. So that is, I guess what Justice Wall is saying, that it was a causation, that they didn't find the harm, that it didn't cause the harm, the intentional, misrepresentation.
I think the hearing panel's finding on the harm was that the harm of losing legal status and the other injuries associated with that by not having legal status in the United States was caused by the initial negligence. And that the hearing panel's finding essentially was that these are not separate harms. They are all sort of bundled into that initial harm. And that is the lack of causation there, because it wasn't the dishonesty that caused them to lose legal status. Our position is that these examples that you read from the findings of fact are the compounding harm. It's the continuation of the harm. And so while it may not have been, there's not a true link between the untrue statements and the losing status, because there was nothing untrue about that. It was a continuation and it made the harm worse, essentially.
And is that the disciplinary administrator's office position also? I guess because you didn't file any objection.
I mean, so every case is different, and I don't know that. Oh, you mean in terms of the causation? I'm sorry, I wasn't understanding you. We did not challenge the initial harm of losing legal status as being not causally linked to the dishonesty, because that is an accurate statement that the dishonesty is not what caused the lack of legal status.
So under that theory, and I'll ask opposing counsel this also, but under that theory, then, if there's initial negligence that causes harm, no matter how great the harm, that subsequent false misrepresentations or fraud, or, no matter how big the misrepresentations are, then the person would never qualify for suspension.
I think it depends on how tightly, for lack of a better word, I apologize for not pulling the word I wanted, this court wants to treat the language of the standards and how it wants to weigh the misconduct. Because, it says causes injury or potential injury, but that doesn't, I don't think the language of that standard means that you can't consider whether it continued the injury, whether it made the injury more, whether a subsequent misrepresentation or other misconduct made the injury more severe, whether it, had other effects on the clients, maybe the misrepresentations after an initial injury where there's not the causal link, were misrepresentations that this court weighs more heavily because it was an especially vulnerable client or victim. There are, I think, a lot of other considerations the court can put into place. And simply the fact that that initial causal link is not direct does not mean that they would never qualify for suspension. If that is the way the court wants to interpret the standards, you can certainly interpret it more tightly.
So on that point, and I'm looking at paragraph 76, which is the paragraph we're talking about in the report. When the hearing panel says 4.6 doesn't apply, the language they use is the panel concludes based on the evidence presented. Is this because no exceptions were taken, and because, at least the way the panel frames it, it's a decision based on the evidence? Is that something we're stuck with? Or to challenge that, do you think you would have needed to file an exception? Or I guess phrased another way, why are you permitted to challenge this without having filed an exception?
We are not challenging I suppose their broad statement that the standard absolutely doesn't apply. I understand your point of then there should have been an exception, but I suppose our argument is that you can find that that standard doesn't apply and still be able to find that the duration and severity of the misconduct and the way it compounded the harm could justify suspension based on weighing the other factors, whether it's mitigators, whether it's looking at.
Kind of the point is, I'm sorry to interrupt, but just real quickly, that the standards are guidelines, but what we look to are our rules. And
Correct.
We have discretion to apply those in a different way from the standard.
Correct. And, this court has said many times that all disciplinary cases are unique and that they are not, it's not always helpful to look at them because each is not binding on another. And I think the various outcomes in cases involving dishonesty toward clients in cases shows that this court has treated those standards differently in different cases. And so, it was our position that because it was not our position that the statement that the initial loss of status, I don't think the evidence, fully, I see I'm out of time, Justice Lickert. I apologize. May I finish my thought?
Certainly, yes.
I don't know that the evidence could have shown that the dishonesty caused the initial loss of status because those aren't the facts that anyone has put forth, and it's not the facts in the stipulation, but nevertheless, I think the way the continued dishonesty impacted the harm can be considered by this court.
I'm sorry, I just have one last question. I know we're pushing time here, but help me understand the probation recommendation, because a one-off negligence it is what it looked to me from the record, not a larger pattern. And then misconduct with the misrepresentation oftentimes isn't amenable to probation. I'm just curious what your thought is, why probation is appropriate
So.
after the suspension.
Yes, so our office, although with the caveat of comparing cases is not always helpful, did look at other cases with similar conduct, and several of those have a short period of a suspension that then the rest of the suspension is stayed for probation. The probation piece is to ensure that something like this does not happen again. There was testimony at the hearing that Mr. Solorio has changed his practice to sort of ensure that he does not ever have clients who are in this particular position in the future, but nevertheless, to ensure that he has the sort of case management and is on top of the cases, that a case like does not get put to the side like it did here, because it was the initial negligence that led to that, the dishonesty and that conduct. And so to cure the case management issues that perhaps led to that negligence could guard against future dishonesty, even though the case law says that generally speaking, dishonesty is not amenable to probation.
Looking back to paragraph 76, is that a typo in that? Is that really referencing 4.62?
Justice Lugard, I would agree with that. I think standard 4.6 is the overarching standard for lack of candor to clients. And so I think it would more appropriately reference subsection or 6.2, as you said.
Is
Yes.
where we really get into that causation
Yes.
language, right? Okay. I just want to make sure I wasn't missing a different causation provision that I should be focused on. So. Okay.
Yes.
Thank you. Anything else?
Thank you.
Madam Justice, may it please the court, Mr. Solorio appears in person with counsel Rick Wynn. I'm ready to proceed. Two of the bedrock duties a lawyer has to his client are, number one, keep your client reasonably informed of what is occurring in their case. You disclose the good, the bad, and the ugly, no matter how bad or distressing the news is. And when asked by your client for a status update, the requirement is that you provide them sufficient information where they are permitted to make informed decisions about what happened. So why are we here this morning with a panel of experienced, well-regarded, respected attorneys coming to you with a recommendation for a public censure? And why are we here this morning with the disciplinary administrator's office having recommended probation without any suspension, with an immediate probation back in December 2023? I maintain there's three primary reasons. Number one, paragraphs 85 and 86 summarize where the panel is coming from. They acknowledge that Mr. Solorio should have told the truth about what was taking place with their case. However, they decide, and I think they are accurate, that the dishonesty did not cause the client's injury. There were circumstances, as they find, that were outside the control of the respondent, and there was no evidence, they find, that had the respondent accurately communicated with his clients, that a resulting delay would have somehow been shorter.
Can I push back a
yeah.
little bit on that?
Sure.
Paragraph 36 concerns me on direct causation caused by dishonesty through silence. And it says the respondent did not refer AE or JE to another attorney in this time period, even though he came to believe they could successfully reapply with different counsel because new counsel could more effectively argue that AE and JE's failure to timely file their adjustments was due to the respondent's failure to provide diligent representation.
Yeah, my response would be the following. Ted Garcia testified at the hearing that occurred in front of these three panel members, a very experienced Kansas City immigration lawyer who is his supervising probation officer, that in his opinion, it wouldn't have mattered a hill of beans difference if they had been referred to other counsel. And the reason was because the failure to timely file the pleading that would have allowed for them to receive permanent status. Once if it's a result of an attorney missing a deadline, it wouldn't have mattered if new counsel had gotten into the case. The only way you could have set aside that sort of a denial of relief would have been had the immigration office engaged in some sort of misunderstanding or error in refusing to allow the pleading or the adjustment to have occurred. So the evidence before the panel was different than what he thought at one point in time during this matter, that if he had referred it to another attorney, it would have been a different outcome. That was not the evidence before the panel.
But this is in the amended final report. And so I understand that his expert or the witness called by the respondent didn't agree with this, but this appears to be the opinion of the respondent himself. And he was an experienced immigration lawyer too, wasn't he?
Yes, he was.
So along those lines, if just say for purposes of my question that the panel is absolutely correct, your argument is absolutely correct, that the immigration status, the actual outcome for the clients would have been no different, regardless of whether the communication had been completely honest or not. Isn't the mere deprivation of a client's ability to control his or her case through decision-making a separate kind of harm that is distinct from what I might describe as outcome-based harm?
Justice Stegall, I would refer your attention to, I guess, paragraph 89 of the amended findings, where the panel said respondent's decision to not take action was an appropriate strategic response to external factors outside of his control. And yes,
But it wasn't his decision to make. Isn't the deprivation of the decision-making process a separate harm? That's my question. And again, regardless of whether it actually changes the outcome.
yeah, I absolutely agree, as I indicated at the outset, that a client has a right to be told what's going on so the client can make decisions about their
If you
case.
take away the decision-making power, you've harmed the client. Again, it doesn't matter whether the outcome would change, right?
And yeah, I guess I would request this court consider harm when deciding this case. The harm that resulted from his missing the deadline wouldn't have made a hill of beans difference during the ensuing years.
Do you think
because
that
they would have been denied their relief regardless of his misrepresentations to the client and his failure to provide them information? So my point is the harm is not there. And if you look to 4.62, and I don't think it's
so just to press the point a little bit, is your answer to me that depriving clients of decision-making power over their own case is not a harm so long as the end outcome is optimal?
I would I would argue that that's what we have here, and I would argue that that's.
So,
I-
so what good is a client's ability to control his or her own case then? It just seems to me that's a fundamental aspect of the lawyer-client relationship. And lawyers can't deprive clients of their control over their own case just by coming in after the fact and saying, well, the outcome was as good as could have been expected.
Yeah, I don't disagree with what you just said.
Okay.
But I also, I guess, would ask this court to look at the fact that 4.62, I'm going to go to it. I don't think there is a typo. Suspension is what is addressed with 4.62 in lack of candor to a client, a misrepresentation to a client. It requires two findings. 4.62 does. One, knowing deception. We have knowing deception in this case. But number two, we don't have injury or potential injury to the client, in my opinion, because what ended up happening was they never would have received the relief that they desired because of circumstances beyond my client's control.
So under your view of these guidelines, the lawyer misses a statute of limitations on a client's $1 million case, and just assume the $1 million is guaranteed, but we missed the statute of limitations. And the lawyer lies to the client about how the statute of limitations got missed. Suspension is not on the table for that lawyer. As a discipline for lying to the client.
In this instance, a malpractice lawsuit was filed.
I don't care about that. I'm talking about the operation of the disciplinary rules.
Yeah,
and in my scenario, the lawyer lied to the client about why the statute of limitations got missed. And you're saying suspension is not on the table as a disciplinary alternative.
I'm saying it's clearly on the table for the reasons that have been indicated here, but under the model rules of the ABA, there's a two-pronged analysis. Clearly deception occurred, but the second analysis that injury resulted from that misrepresentation is not there.
Which gets me back to which my question's premised on the guidelines. And so we're back to the guidelines, and you're saying suspension would not be on the table using the ABA guidelines under my scenario.
It appears to be the case, yes.
Okay.
And just to clarify, my question was just that whether the reference in that particular paragraph to 4.6 was wrong, that it meant to be 4.62.
Oh, I'm sorry.
So, sorry, I was, yeah.
Okay. That's
just to be clear.
Reason number one is what I've alluded to, which is it wouldn't have mattered whether he had fully disclosed or not. The ultimate outcome would have been the same. The second reason that I believe that the panel came back with a recommendation of public censure is because Mr. Solorio is the son of immigrants. His father came to this country without legal status. He firsthand witnessed what coming to this country illegally results in with regard to his clients and growing up in that environment. He knows that serious trauma occurs to these people, that it's not uncommon to see these people do their grocery shopping in the middle of the night, that they withdraw their kids from schools out of concern that it's going to somehow result in an arrest of the parents, and they just basically go into hiding. So it's to him, and he did wrong, and he's going to get up here and tell you he did wrong. He should not have allowed the model or the rules of professional conduct to be disregarded, but his motivation was the extreme trauma that it was going to cause to his clients.
Can I,
No, go ahead.
just real quick on that point, I want to give you a chance to respond to something that puzzled me a little about the panel's report, which goes to the motive question. The panel clearly found there was no selfish motive to this. But just looking at it afresh, it strikes me that one obvious possible reason for the dishonesty is to prevent oneself from being fired and to prevent a malpractice lawsuit from being filed against. So I just want to give you a chance to respond to, like,
On the first, I would just tell you, his wife jokes about him being a pro se lawyer, or a lawyer that represents clients that don't pay. $900 was his fee that he charged these people. So he wasn't in it for the money. But yes, I mean, your point is that could make the argument. He's going to tell you that didn't enter my mind. My concern was about my client's well-being, emotional.
and there
well-being.
is clearly a panel finding on that point. Thank you.
The
I was
third,
going to add to that, kind of spoke to it a little bit just in your last comment about your client appreciating the vulnerability of their status, where they're at, why they're seeking representation in the first place. How much should that factor? These clients were especially vulnerable compared, and again, I agree with Ms. Butler's, you don't want to compare cases, but in other situations, clients are on a little more solid footing, have more comprehension of their legal status and rights. Here, the very nature of this relationship is they're relying on his representation to get their status in order. This is what they're seeking to do. This is probably their lifelong goal. Does that factor in? How did the hearing panel, how do we factor that in? I think this represents really the crux of what a lawyer-client relationship is to protect the interests of their clients, especially vulnerable clients.
let's just go with the scenario, Justice, as you've described it. He fully discloses, this is what I did. Trump administration is now in place. I can't do anything for you. That versus not telling them with, I'm moving forward with your case as best I can. That scenario arguably puts his clients in a better emotional state than the other, which is, you're out of luck, sorry. And so that's the analysis that went through his head. He was between a rock and a hard place, and he chose to take their emotional well-being as a priority. The third reason, and I'm almost out of time here, and I'm going to ask my client be allowed to address the court, but the third reason is there is a published opinion in Re Rundus, and a 1999 case that involved, it's 267 Kansas 790, involved similar facts and circumstances. The attorney represented his former basketball coach, and the former basketball coach wanted lawsuits filed in Jackson, Wyandotte, Jackson County, Missouri, Wyandotte, and Johnson County for collection cases. The attorney represented to his client that all three cases had been filed and was deceptive about there being certain chronology of settings to occur, and that he was moving forward on all those cases. That never happened. That was a complete fabrication by the attorney, and a malpractice lawsuit was filed later on, just as it was here. In that case, the court considered no disciplinary record. My client has no disciplinary record. He fully cooperated with the disciplinary administrator. My client did in this instance. There was support for character from judges and lawyers, same situation in the Druten case, and demonstrated remorse, same. So I'm just saying that there is precedent out there for an extended period of deception going on between an attorney and his client that ended up in a public censure in that case. Some other cases where you've recently decided in the matter of Spencer, a 2023 case involving a former assistant county attorney in Sumner County, who not only lied to law enforcement about a misdemeanor that was being investigated, but then mitigated his situation when responding to the disciplinary administrator's complaint. This court issued a public censure. And I realize there's not a history of years involved in that, but there is precedent for public censure taking place in situations where there's been knowing deception provided by the attorney in a considerable way. I'm going to ask my client be allowed to address the court.
You certainly.
Good morning, and thank you for the opportunity to address the court. I was born and raised in the Bay Area, California. I come from a family of immigrants. My father came to the US and worked as a migrant farm worker in California, and my mother worked in the tomato canneries. As I matured, I became more aware and started volunteering at the Mexican American Legal Defense and Educational Fund. And it was there that I found my purpose. I knew I wanted to go to law school and give back to my community from a position where I could make a difference in the lives of my Latinos. I applied to law school for the sole purpose of becoming and practicing immigration law. My practice is certainly my livelihood, but I see myself and my family and my clients because I come from a family of recent immigrants and I can relate personally to their hopes, dreams, and struggles and yearning to do better for the sake of their children. I'm an attorney and I'm one of the fortunate to serve in this capacity, regardless of what type of law one practices. I specifically devoted myself to immigration law because the people I represent are important to me. I'm passionate about my clients. Never have money been for money. As mentioned earlier, if you ask my wife what type of law I specialize in, she'll respond pro bono. I'm passionate. In the case before us, I apologize to my client for not providing full disclosure. I understand, as one of the justices mentioned, they had the right to make a decision on their own case, and I did not allow that. I've failed to provide them with accurate information regarding their case. Even though my intention was not to panic them or increase their stress, they were entitled to the entire truth about their case. I understand my failure to properly communicate the entire situation of my clients is unacceptable and in violation of the rules. At the time my client's case was denied and not referred to the immigration court for a second review, it was 2017, and everything changed with the Trump administration's harsh changes to the immigration policy. During the Trump administration, immigration practitioners were stuck between a rock and a hard place. The risk of having my clients removed or detained for an extended period of time was entirely possible, and since they had minor children, it was not a viable option. My decision to not take action immediately on my client's case after the late filing was a strategic response to the contemporary political climate. During the Trump administration, immigrants and their minor children lived in fear. It was so great that they adjusted their activities to hopefully minimize the risk, such as grocery shopping at night, not sending their children to school, not attending church services, and even stopped applying for benefits that their children were entitled to in fear that ICE would be contacted. I made a legal strategic decision to wait for a reversal to normal policies and procedures which occurred when the change in administration occurred in January 2021. Fortunately, my failure to properly communicate did not make the clients ineligible, and they are back in status and on track to gain permanent residency if they haven't already. To ensure this doesn't happen moving forward, I've incorporated numerous changes to my procedures in the past 2.5 years. I've reduced my backlog. I have not taken removal cases or asylum cases, and I have also reduced the number of consultations I do, and I am no longer accepting U visas cases, which will further reduce my case log. I continue to be monitored by supervising attorney Theodora Garcia, monthly by telephone and quarterly in person. Mr. Garcia is a well-respected immigration lawyer who practices in Kansas City metropolitan area. If you're wondering how I will handle the next administration, I've been preparing myself. I've already attended many local and national seminars and work groups that have met various relevant figures in the community. I was recently one of Kansas City immigration attorneys who were invited to an important meeting with the Mexican consulate in Kansas City with 40 other professionals to address and anticipate the changes under the incoming administration. Regardless of the political climate, my clients will continue to find me attorney who not only advocates for their best interests, but also relates to them on a shared cultural background and immigration experience. I pray that this court concurs with the recommendations of the hearing panel and that be issued a public censure. If you have any questions, Justice, I'll please take them.
I just want to have clarity for in my own mind.
Absolutely.
As I understood your counsel's argument, and you even touched on it in your presentation just now. your position and what you've represented to us is that you made a strategic decision not to share the information with your clients because you, in good faith, believed that not sharing the information was actually in your client's best interest. Is that correct? The way I just said that?
Yeah. In retrospect, the proper thing to do, I learned, was to refer this to an attorney.
Sure, and you've admitted that, but I
Yes.
want to get into your state of mind
Yeah.
at the moment the
Yeah.
decision was made. And again, it sounds to me like the position or what you've described is that at that time, you in good faith believed that withholding that information was actually in your client's best interests. And I understand you later are admitting that, no, you should have disclosed it, but is what I said accurate as to your state of mind at
Yeah.
that time?
At the time, my motivation was to reduce the stress on my clients. They hired me to gain their permanent residency, and I failed to do that. And I didn't want them, with the way things were at the time, to stress them out or cause any harm. At the same time, I've already made some legal analysis of how this is going to go forth from the time that I got denial. In general, most cases that are denied, or most all cases, are referred to an immigration judge for a second review of the case. I knew I could have gotten the approval at that time. So I just honestly thought that I'm going to get them the residency, it's going to continue. And unfortunately, it didn't happen. And that's when the new administration came in and it became more difficult.
Okay. When this blew up, in terms of your clients finally realizing what's going on, why didn't you self-report?
Yeah, I should have referred. Looking back now, that would have been the proper thing to do, Your Honor. Your Justice. Are there any other clients? Any other questions? I'm sorry.
See none. Thank you.
Thank you.
Unless this court has any particular questions for me, I would waive my rebuttal.
I have a couple questions, no
Absolutely.
surprise. I suppose this is sort of it's almost a law school type question. Is it plausible at all that it might, in certain rare circumstances, be in a client's best interest not to be told what's going on? In other words, for the attorney to shield the client? Is that even hypothetically possible?
I believe, Justice Stegall, it's not only hypothetically possible. My recollection, and I do not have my rule book in front of me, is there's a comment to, I believe, 1.4 that speaks to the idea of it may be appropriate to not to never tell them, but to wait or to rephrase or to, find ways to share information at a time or in a way that is not going to be seriously detrimental to the client. I don't know that that comment is thinking about a period of a long time, but if you had a client theoretically in crisis and what has happened in their case could really harm them, maybe waiting a few days or.
So my follow-up just is, I wanted you to respond to this, which is, if I sort of squint at the facts here, I can at least understand the plausibility of the argument that, look, yes, I was dishonest and technically should have disclosed, but if you look at what happened, my strategy actually kind of worked. Like they didn't panic. They didn't make a emotionally charged decision with the new administration that was unfriendly to their status. I waited them out. We got a new administration, and all's well that ends well. Just wanted to get your response to that.
The rules overall, and there are rules that I think are implicated by your question that were not pled and are not in play in this case, recognize that an attorney's duty is to be an advisor to their client and let their client know fully what's going on in the way that is appropriate for the client. You don't talk to a 12-year-old client the same way you talk to a savvy 72-year-old client or anything like that, but that the clients do have an understanding of what's going on. And while it may be appropriate in times to couch information, to delay to avoid some sort of crisis, to say, well, if it's all's well that ends well, a period of substantial duration of, I see that I'm out of rebuttal time. May I finish this
You
thought?
may.
Thank you. A period of substantial, not just couching or sugarcoating information, but not providing the real information. Oh, things are happening when they were not. That goes against not just the letter of the rules, but I think much of the spirit of an attorney's duty to their client. And so while that is, certainly the outcome of no matter what I told them may not have changed what happened, is a factor that can be considered when weighing things such as the harm. It is, our rules recognize that the attorney needs to be forthright with their client and advise their client, as 2.1 says, sometimes of things beyond just their case.
I understood the argument to actually be slightly different, which is, had I told them the truth, my judgment, my professional judgment was that their outcome would have likely been worse.
I don't know that there is evidence of that. In the record, at least, certainly that they would have been upset and fearful, and many people were, but I don't know that there's evidence that, at least in this case, there would have been a direct and immediate detrimental outcome.
Thank you.
Any other questions? Thank you.
Thank you.
Thank you to all of you for your arguments this morning. The court will take this matter under advisement. Now call case number 128210. Are you ready, Ms. Harper?
May it please the court, Gail Larkin, Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator. Chief Justice Lucard, I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. This is an original action in discipline filed by the Disciplinary Administrator's Office against Re Rundus. The court admitted Mr. Rundus to the practice of law in 2007. On April 3rd of this year, the court entered an order temporarily suspending his license following a felony conviction. His license remains suspended at this time. On August 23rd, 2024, the Disciplinary Administrator's Office filed a formal complaint against the respondent alleging violations of KRPC 8.4 and Supreme Court Rule 219. September 18th, the parties entered into a summary submission agreement, which details the agreed upon facts, rule violations, recommendation for discipline, as well as the consideration of the ABA standards. On December 5th, by permission of the court, the parties amended the summary submission agreement to include facts and evidence regarding the respondent's compliance with the terms of his Republic County probation that he remains on today. In the summary submission agreement and the amended agreement, the parties jointly recommended that the respondent be suspended for 1 year, and that prior to reinstatement, he undergo a hearing to consider the reinstatement of his license to practice law. The facts in this case are straightforward and agreed upon by the parties. Between March 3rd, 2023 and June 30th, 2023, a period of 4 months. Took me a long time to calculate that. Not good. That's why I don't do math. The respondent was arrested 3 times for driving under the influence of alcohol. The respondent went unrepresented in all three cases, and all three cases resulted in a conviction based upon the respondent's plea. Third conviction is a felony conviction for which the respondent remains on probation. I want to talk a little bit about what Mr. Rundus has done since that third conviction. He has completed the alcohol treatment required by the probation order. He participated in outpatient treatment for 13 months. Originally, it was intense outpatient treatment, and I think that lasted about a year, and then a good 6 months, and then for the remaining time, it was stepped down to continuing to be outpatient, but not the intense level that it had been. On October 7th of this year, he was released from treatment. And further, it's important to note that the last time he consumed alcohol was the night of his third arrest. He has not consumed any alcohol.
I'm
since
sorry, you trailed off there when
Oh,
you were
sorry.
getting to the date.
The night of his third arrest, which is June 30th, 2023. It's been nearly 18 months. The respondent has complied with all provisions of the probation order, and if he's able to complete the remaining hours of community service work by February 5th, he and his probation officer expect that he would be released from probation a year early. The Rule 223 adopted by this court in 2021 allows the disciplinary administrator and a respondent to enter into an agreement regarding the facts, the rule violations, and a mutual recommendation for discipline. Summary submission serves two important purposes. It allows respondents to take responsibility for their actions, and it also allows that disciplinary cases proceed through the system sooner rather than later. I recognize that summary submission is not appropriate in every disciplinary case. It's appropriate to consider an agreement like this in those rare occasions where both parties, the disciplinary administrator and the respondent, agree to all the facts, all the rule violations, and the recommendation for discipline. This is one of those rare disciplinary cases where summary submission is a perfect fit. The parties agreed to all of the facts of the two rule violations and the recommendation for discipline. The facts in the amended summary submission agreement and the original summary submission agreement are nearly identical to the facts in the formal complaint, with some added information recently about the respondent's compliance. Under Rule 223F, the Supreme Court is not bound by the rule violations that the court finds, nor is the court bound by the recommended discipline. So I want to address those two areas in a little bit more detail. In the summary submission agreement and the amended agreement, the respondent admitted that he violated KRPC 8.4B for engaging in criminal conduct that adversely reflects on his fitness to practice. And he stipulated that he failed to report those charges and convictions as required by Rule 219. There are no other rule violations asserted, and those are both clearly established by the facts contained in the summary submission agreement. So then the next step is to discuss the recommendation for discipline. And in the summary submission agreement, we went through the ABA analysis, looked at the duties violated, the mental state or the level of intent of the respondent, and the injury or potential injury that was suffered. In this case, the respondent knowingly violated his duty to the public and to the profession by committing criminal acts. As a result of the respondent's misconduct, he caused potential harm to the public and to the legal profession. Luckily, no actual harm to the public occurred in these three DUIs. Based upon the duties he violated, the level of intent, and the potential for injury, the respondent and the disciplinary administrator's office agreed that standards 5.12 and 7.2 apply. Both of those standards indicate the presumption is suspension. Consideration of aggravation and mitigation can change that depending upon how compelling the evidence is on both regards. Parties agreed that there was a pattern of misconduct, substantial experience in the practice of law, and illegal conduct as the aggravating factors in this case. The parties also agreed that the absence of a prior disciplinary record, the absence of dishonest or selfish motive, the personal and emotional problems experienced by the respondent during this time, and the imposition of other penalties or sanctions are the official mitigating factors that are present, and those were all included in the summary submission agreement. In addition to those standard factors, there's a couple of additional, I think, mitigating or pieces of evidence that were presented that are also mitigate the misconduct in this case. Number one, he has not consumed any alcohol since his third arrest. He's done very well on probation. He completed the alcohol treatment, and he is on course to be released from probation a year early. Of course, there's no client harm in this case. This is a case that occurred outside the practice of law. And the fact that there is no client harm also, I think, is a mitigating factor. I think that the mitigation outweighs the aggravation in this case. So while it's, I think it remains in the realm of suspension, but it's not it's not so compelling that it would kind of result in a lesser sanction. But I think it supports a shorter suspension as compared to other similarly situated disciplinary cases.
You may have just answered one question I had. It looked like, looking at some of our similar cases where there are 3 or around that area of DUI convictions, suspension's been typically a 2-year suspension.
Correct.
And I'm hearing that maybe it's the aggravating or the mitigating circumstances here that moves you off of that. But I guess my question is, for consistency, does a longer suspension make sense with, and why no consideration of a stay, I guess? Is it just because it's the 1 year and that's the appropriate length given those mitigating circumstances? I'm just trying to see how it fits in with some of our other cases like in Re Cure, Davis, Hardy, and Hubin.
Certainly. I mean, I think if you look at Hubin in particular, and perhaps the Davis one that was decided earlier this year, those both, the net result was, in the Hubin case, no suspension other than the temporary suspension that she experienced after the conviction before the disciplinary case was resolved. And in Mr. Davis's case, the same thing, but with that additional 6 months. And so those were certainly shorter periods of time, given the
Stays.
given the stays and given the I guess the bottom line. But if you look at some of the other cases that didn't have those stays and those things, 2 years is pretty universal. I looked at 8 different cases. And, there was a 2-year suspension in Davis. After 6 months, he received probation. The suspension was not made retroactive to the date of his temporary suspension. In the Cure case, there was an 18-month suspension. It was made retroactive to the temporary suspension, but he also was required to have a reinstatement hearing. So when you have the different factors, the retroactive and the reinstatement hearing, that really impacts the length of the suspension. And in this case, I think that a 1-year suspension is appropriate, even though it looks like 1, 2, 3, 4 of the cases I looked at had 2-year suspensions with certain modifications. 3 of the cases had indefinite suspensions. And I want to address 2 of the cases that had indefinite suspensions. The Meyer case from 2015, Mr. Meyer had been convicted of DUI on 7 occasions. And I think that just takes it outside the comparison in this case. In the O'Neill case, which is the other indefinite suspension case that had kind of additional information, it was from 2007, and he had been convicted of his 3rd DUI after being admitted, but he had been convicted prior to being admitted and had lied on his bar application. And there was additional misconduct that was involved. There was certainly a lack of taking responsibility for his actions and that kind of thing. So again, I don't think that one, I think that's kind of off the radar as well. The only one that's a little bit, maybe would require a little bit more explanation is that Laskowski decision from 2006. It was also an indefinite suspension, and that was made retroactive to the temporary suspension. But I think that given the circumstances in this particular case, the significant mitigating factors, I think that a 1-year suspension with the requirement of a reinstatement hearing extends that suspension because of the process it takes to do the reinstatement. Typically, it's about 9 months, and so it adds that time.
And the effective date you want the suspension for your recommendation is the date of the opinion or retroactive or?
You took the words right out of my mouth. Because he's done so well on probation, I I believe he deserves to have, and maybe deserves is not the right word, but I believe it's appropriate for the suspension to be made retroactive to the date of his temporary suspension. And I make that recommendation, even though it's not in the summary submission agreement, because of what he has done since we entered the summary submission agreement. He's taken a lot of steps, and there's a couple of cases I wanted to,
Can
Well,
I ask,
go
just while we're on that, how does that fit with the recommendation that he be released from probation? That one of the things he showed at his 229 hearing is, or I'm sorry, that's what it's gonna be for me for a long time.
232.
232
Yes,
hearing,
I know.
is that he had, been released from his criminal probation.
Correct.
So give me the timeline of how that all
Fits
you know,
together?
Yeah, fits. I mean, especially because I understand the dates that there's a hope he will be released a year early from
Sure.
that. What happens if that doesn't occur?
Well, if the recommendation is made retroactive to the date of temporary suspension, which is April 3rd, then he would be eligible to apply for reinstatement April 3rd, 2025. But I think this court should include requirements that have to exist before he can apply for reinstatement. So number one, that he has satisfied obviously the standard language of any orders in the court's opinion, but as well show that he has been released from his criminal probation before he's allowed to apply for reinstatement. So if he doesn't get the community service work hours done by February 5th and he remains on probation for a longer period of time, that would impact when he should be able to apply for reinstatement. That should be a condition precedent. But I think that, one of the things that I saw a little line in, I think it was the Cuban case, and I think that the circumstances, the Davis case were kind of consistent. And it said that in the Davis, or in the Cuban case, the respondent has made concerted and consistent efforts to address the root cause of the misconduct that gave rise to the disciplinary case. And I think that's present in this case. And that's why I think he should be given the benefit of the doubt and be allowed to apply for reinstatement sooner rather than later. I think that encourages that level of cooperation and interest in maintaining his sobriety and receiving the treatment that he needs to receive going forward.
The outpatient treatment you referenced then apparently addresses both underlying systemic problems, perhaps with depression, or at least episodic problems with depression, as well as alcoholism, or how does that, or, is it a dual diagnose? I don't know what the specifics are of the diagnosis or the treatment.
I don't know that I'm equipped to answer that question. I think that maybe Mr. Rundus might be in a better position to. I did note in the discharge summary that they didn't recommend any additional treatment, any treatment for depression. However, in my conversations with Mr. Rundus, I believe that is an ongoing issue that he needs to address before he should be reinstated. And so that would be something that I would, at the reinstatement hearing, want to see that he has obtained sufficient treatment to address his depression. But in the discharge summary, it specifically didn't refer him or the discharge plan for additional treatment. Any other questions? I see I'm out of time. I apologize for going over.
I have a couple questions. I did see in that they do recommend let's see. I can't remember. It's in volume 2. Okay, challenging, blah, blah. The counselor does believe that when Lane is ready, he would benefit from mental health services to address his ongoing depression, but also understands that during, I guess, the year that he'd been there, that he had not found a mental health practitioner he is satisfied with.
In the plan going forward, there wasn't any specific referral or whatever. And that's what I'm talking about. I think that once he gets to the point where he's ready to do that, that all has to have happened before the reinstatement hearing. So he can prove that he is in a place where he can handle the practice of law.
Okay, so do you know whether or not, and I guess I could ask him when he comes up, but it seems like a really big issue as I'm going through this is his lack of health insurance. Do you know whether he has health insurance now?
I do not.
Second of all, he's been great in complying and for a whole year, and was released on October 7th. And he's been clean, and I'm assuming that they have him drop UAs, but he's also was dropping and is dropping UAs on his criminal probation, which if he comes off of that, which it looks like might be February 6th, 2025, what will the incentive be for him to not drink? I mean, right now, his probation would be revoked and he would have to serve an underlying sentence.
You know, in reading the discharge summary and the discharge plan, I noted some of the statements that Mr. Rundus made about the benefits that he has received physically and personally by not drinking, and that, you know, he has no intention of resuming that because of his recognition of where it took him and how much better he is feeling and doing without drinking.
So his diagnosis at admission and at discharge on October 7th is alcohol use disorder severe. So I understand what you're saying about the desire
Certainly.
to, you know, that he feels so much better, but
I do.
as of February 6th, 2025, he will have no accountability at all, and he might even be without health insurance. But maybe these are better questions for him.
I certainly think that a KLAP monitoring agreement at the time he comes back to the practice of law would be in order, perhaps, you know, some sort of probation. But in my discussions with Mr. Rundus, it sounds to me like it will be some time before he applies for reinstatement because he wants to be able to take care of some of these personal items. And he can certainly address that better than I, but that's definitely been our discussions, that he, you know.
But I thought you said that if you count it retroactively, his suspension, that he would be eligible April 3rd, 2025. So he's said to you that he doesn't plan to seek reinstatement in April of 2025?
Absolutely. I've made the recommendation because I think that his hard work deserves that recognition. But my understanding is he will not be applying for reinstatement until he feels that he is ready and he's been able to take care of and get his depression under control and has the proper tools in place to be successful. But my recommendation, and I kind of sprung it on him this morning. I didn't tell him I was going to recommend that until today, but I've been very impressed with the strides that he's made and the concerted effort he's made to really turn his life around. I mean, he had 4 really bad months in 2023. And it was really kind of this isolated period of time. And I think that by giving him kind of that light at the end of the tunnel, knowing that he can apply for reinstatement whenever he feels ready, I think that that would be an incentive for him to continue to work his program and to seek the assistance that he needs.
Thank you.
There's no other questions? Thank you.
Mr. Rundus?
Lane Rundus, pro se, and may it please the court. Thank you to the court for this opportunity. I'd also like to thank the disciplinary administrator's office for their professionalism, their diligence, and quite frankly, their consideration for not only the rule and practice of law, but for me as a violator. So I failed. I failed the profession, the rules of professional conduct, my family, and my community. I failed my own conception of my character, my values, and the very simple notion that I was a decent person. The only solace I take in my actions was that I was not practicing law at the time of my those actions. I understand that I do not deserve really to keep my license. I also know that I am not well enough to practice law. And to address Justice Standard's question earlier, I have no intention of practicing law in the near or distant future.
You know, I didn't understand from the record, I probably missed it, that you weren't actively practicing law.
I haven't
in the
actively.
spring of 20, I'm sorry, go ahead.
I apologize.
That's okay.
I haven't actively practiced law since August of 2021.
Okay. Thank you.
I have helped. I moved back to Munden, Kansas. And so when the local farm boy lawyer comes home, the neighbors start calling with questions. And so I answered some questions, but I never held out my I never held out a shingle or held myself out as a lawyer. It was just family, friends that had questions about a wind lease or something along those lines, but I never took payment. I never advertised myself as a lawyer. It was basically just family, friends that would corner me at the coffee shop or something like that. So, but no, I understand that I self-medicated my depression with alcohol. I have had a flitting relationship with health insurance. To a certain extent, it was I've pursued it and then not pursued it, and then the concept of putting gas in a car you've already wrecked was kind of a reason against pursuing health insurance as vigorously as I could have or should have. I've maintained efforts to secure mental health. Prior to all of this, I had I'd sought mental health treatment prior to April of 2022, and I continue to pursue and receive mental health treatment today.
What are you doing along those lines? It appeared from Ms. Larkin's presentation that you completed your alcohol treatment, but is there anything ongoing at this point?
Yes, I continue to pursue mental health treatment through an online service at the moment.
And how, tell me, just so you don't have to go into great detail, but what do you
Once
do?
a month.
Okay.
And ARC to address the other previous questions, the facility that I received my intensive outpatient treatment at was geared more towards drug and alcohol abuse specifically, and less so about mental health. Although mental health, as I'm sure this body understands, is that mental health and criminality, which was where most of those folks came from, go hand in hand in many instances. So the nature of the substance used to self-medicate in this instance was pretty universal. And so, although it was primarily alcohol treatment, I was there because of DUIs. That's what they treated me for, was alcoholism. But I think my primary issue is mental health, less addiction. So I'd stand for any questions.
Again, kind of more of a just what happened with your criminal cases. You've had 3 DUIs.
Yes.
And it looks like it only resulted, how much jail time did you do?
I spent 48 hours with the first DUI. The second DUI took place in Nebraska. So I served at a 30-day sentence in Nebraska. And then my felony DUI, I think, resulted in 5 days of incarceration, and then an underlying sentence after that.
And the underlying sentence didn't include a mandatory 90-day jail for the felony?
No.
And what is the, I know that we've talked about a possible early discharge from probation, but what would be the full term of your probation from?
I believe it's 2 years from February. So it'd be February of 2026, I believe, would be the full term. But I don't have that information at the ready, and that's my best guess, Your Honor, Your Justice.
And having to spend some time in Mahaska and around Munden and up into Hubble, Nebraska, are services, access to services an issue currently for you?
The city of Belleville does not have a city attorney and hasn't had one for a few months. There is one practicing attorney that lives in Scandia, but that's the only, to the best of my knowledge, that's the only attorney that lives in Republic County.
I meant more for your own mental health or any other services that you might feel that you need moving forward.
I use it online.
Online and that's been enough.
I do not drive at the moment as well. So
Yeah.
that's another compounding issue.
Is it the same person every month or is it a different person every month?
It could be the same person every month, and it has been the same person several times, but sometimes schedules don't allow and align, and so it's hard to. Continuity has been an issue.
And thank you for, your driving privileges are currently suspended, or are you doing that by choice? What's your status with that?
I pursuant to the present law, I have a 3-year suspended license. I was eligible to have a reinstatement, have it reinstated and with the interlock device. I have chosen not to do that at the moment because it sounds silly, but there's a penance to pay for my actions. And I know it's inconvenient for those that are tasked with ferrying me here today. But I'm a felon, and it shouldn't be easy to be a felon. No other questions?
Questions? Thank you.
Justice Rosen, I would like to clarify that after he was released from the 5 days of jail on the felony conviction, he did serve a term of house arrest. It was only 30 days. It was not 90 days. That's Exhibit 8 on page 75 as a journal entry.
Yeah, the law must have been amended from what I was familiar with, because it used to be on a third and subsequent mandatory 90 days up to a year, and that was pretty strict. So I guess it's been relaxed. So
I don't think it has. I don't think it has. I actually did some research on a different case, and I think that it's the same as you and I recall from some time ago. So I'm not sure. I'm not sure how that happened, but I would stand for any additional questions. I would waive my time. Thank you.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. Court is now in recess.